Hi friends, I am Professor Kshitij Bansal and I teach environment law at Chintal Global Law School. Let me brief you today on right to environment and its relevance in terms of regional as well as national level. What would you be learning after listening to my briefing? You would be understanding the scope of right to environment at various regional levels: North American, African, European. You would understand the scope of right to environment in different countries in their respective domestic legislations and constitutions. And lastly, also the most important, you would understand the right to environment as it exists in India. The development of right to environment as an independent right at international level has influenced the identification of right to environment at regional and national level. International level right to environment, just like the regional level, both of them can be identified as a derivative right and as a distinct right. On the regional level, the African Charter on Human Rights and People's Rights of 1981 was the first human rights instrument to include a specific, explicit guarantee of right to environment. Many countries have also recognized rights to environment in their national constitutions. The various regional and national constitutions would be discussed later on in this briefing. Let us first begin by discussing right to environment at regional level. American Declaration of the Rights and Duties of Man, 1948, establishes civil, social and cultural rights similar to those of subsequent human rights instruments, including the right to life, right to equality before law, the right to religious freedom and worship, right to protection of private and family life, the right to preservation of health through sanitary and social measures relating to food, clothing, housing, and medical care, the right to take part in cultural life, and right to property. Each of these rights is potentially implicated by environmental degradation. The Inter-American Commission on Human Rights has held that Article 1 of the Declaration can be violated by severe American pollution if such pollution causes serious physical illness, impairment and suffering on the part of local populace. The Commission stated, the realization of the right to life and to physical security and integrity is necessarily related to and in some ways dependent upon one's physical environment. Accordingly, where environmental contamination and degradation pose a persistent threat to human life and health, the foregoing rights are implicated. The Commission has also found that environmental degradation can affect various other rights mentioned in the Declaration. Talking about the European region, European Convention for the Protection of Human Rights and Fundamental Freedoms of 1950 focuses on individual liberties, including civil and political rights and freedoms in Europe. 14 protocols have been added to the Convention. The Convention does not expressly link human rights and environment, but the European Court on Human Rights has determined that environmental degradation can interfere with the enjoyment of protected rights, including the right to life, respect for private and family life, fair trial, information and effective remedy, and also peaceful enjoyment of property. All these rights would be affected by environmental degradation. Let us specifically talk about the American Convention on Human Rights of 1969 now. This convention provides for various substantive and procedural rights which can be related to environmental protection, including the right to life, humane treatment, personal liberty and security, a fair trial, privacy, freedom of expression, and access to information, use and enjoyment of property, participation in government, and etc. The American Commission or the court have found that these rights are relevant in cases involving environmental degradation. Similarly, there's another important African regional convention, which is the African Charter on Human Rights and People's Rights of 1981. This charter was the first human rights treaty to expressly recognize the right of all peoples to a satisfactory environment favorable to their development. In Article 24, the Charter explicitly states that all peoples shall have the right to a general satisfactory environment favorable to their development. Article 21 provides that all people shall freely dispose of their wealth and natural resources, and adds that this right shall be exercised in the exclusive interest of the people. The Charter contains several additional rights related to environmental rights. For example, the freedom of conscience and religion, the right to enjoy the best attainable state of physical and mental health, and the right to have his cause heard. All these rights are relevant in the context of protection of right to environment. Talking about an important region of the world in terms of its regional integration and regional regulation, ASEAN, Agreement on Conservation of Nature and Natural Resources 1985, ASEAN states have recognized environmental rights through this agreement. Through this agreement, Article 16 provides that contracting parties are required to circulate as wide as possible information on conservation measures and their relationship with sustainable development objectives. The parties have a duty to organize the participation of the public in the planning and implementation of conservation measures, which are considered fundamental to environmental protection. Additional protocol to the American Convention on Human Rights in the area of economic, social and cultural rights, popularly called the Protocol of San Salvador 1988, expressly links human rights and environment. Article 11 proclaims that everyone shall have the right to live in a healthy environment and to have access to basic public services. It also affirms that parties shall promote the protection and preservation and improvement of the environment. In addition, it recognizes the right to health, right to food, right to benefits of culture. Each of these rights could be implicated by environmental degradation. European Social Charter 1996 takes the European regulation and the identification of environmental right further. This charter contains guarantees for social and economic rights. It provides a number of provisions which, like provisions similar in ICESCR, and may depend on consideration of the quality natural environment for their effective implementation. For example, the right to safe and healthy working conditions, right to health and right to adequate housing, natural disasters, toxic pollution and climate change can all destroy the enjoyment of these rights and create obstacles to the implementation of this right. Aarhus Convention on Access to Information, Public Participation in Decision Making and Access to Justice in Environmental Matters 1998 is another important international regional legal document. This convention is considered as one of the world's most advanced international agreements concerning environment, both guides sustainable development and strengthens basic democratic principles. It requires that all environment-related data be managed openly and that civil society and all relevant stakeholders should have access to information, and they should be allowed to participate in policy making and have the right to live in a healthy environment. In order to protect the right of present and future generations to live in a healthy environment, Article 1 of Aarhus Convention requires signatory parties to guarantee rights of access to information, public participation in decision making, and access to justice in environmental matters. It lays down a set of basic rules to promote the involvement of citizens in environmental matters and improve enforcement of environmental law. The Charter of Fundamental Rights of the European Union of the year 2000 provides in Article 37 for an express protection of right to environment. It provides that a high level of environmental protection and the improvement of the quality of environment must be integrated into the policies of the Union and ensure in accordance with the principle of sustainable development. Let us now talk about national constitutions. Many national constitutions and laws recognize the right to a healthy environment derived from the obligation of state to adopt principles reflected in the Stockholm and Rio declarations. Portugal, India, and Spain were the first countries to include the right to a healthy environment in their constitutions. Article 66 of Portuguese constitution states, everyone has the right to a healthy and ecologically balanced environment and the duty to defend it. Since the mid-70s of the 20th century, various countries have granted constitutional status to this right. Constitutional law experts observe that recognition of environmental rights has grown more rapidly over the past 50 years than any other human right. An analysis of different constitutions in the world reveals that there are 5 divergent approaches towards the recognition of right to environment. The first group of countries which considers protection of environment is the duty of state. The second group of countries expressly confer right to environment to its citizens, and the third group of countries imposes an obligation to its citizen to protect environment. The fourth group, not directly addressing right to environment, guarantees various dimensions of right to environment, such as right to clean and potable water, clean air, and sustainable development, etc. The last group consists of countries which are not yet included right to environment in their national constitutions. Some of the examples of all 3 approaches are as follows. First group, which is about identifying right to environment as a duty of state. This group includes countries such as Afghanistan. The state is obliged to adopt necessary measures for safeguarding forests and environment. Chile, the right to live in an environment free from contamination. It is the duty of the state to watch over the protection of this right and the preservation of nature. El Salvador, it is the duty of the state to protect natural resources and the diversity and integrity of the environment to ensure sustainable development. Mali, every person has a right to a healthy environment. The protection and defense of the environment and the promotion of the quality of life is a duty of everyone and of the state. Turkey, it is the duty of the state and citizens to improve the natural environment and to prevent environmental pollution. The second group, which is the group of countries where specific right to environment is expressly guaranteed to its citizens. This group includes countries such as Benin. Every person has the right to a healthy, satisfying and lasting environment and has a duty to defend it. The state shall watch over the protection of environment. Russia. Everyone shall have the right to a favorable environment, reliable information about its condition, and to compensate for the damage caused to his or her health or property by ecological violations. Ukraine. everyone has the right to an environment that is safe for life and health, and to compensate for damages inflicted through the violation of this right. Everyone is guaranteed the right of free access to information about the environmental situation, the quality of food and consumer goods, and also the right to disseminate such information. No one shall make such information secret. The third group, which is the group of countries where right to environment is general duty to respect. This group includes countries such as Estonia, a beautiful country in Eastern Europe. Everyone has a duty to preserve the human and natural environment and to compensate for damage caused to the environment by him or her. The procedure for compensation shall be provided by law. Kyrgyzstan, where everyone must take care of the environment, flora and fauna. Mongolia, it is a sacred duty for every citizen to work, protect his or her health, bring up and educate his or her children, and to protect nature and the environment. The fourth group, which is the group where different environmental rights are recognized. This group includes countries such as Kenya. Every person has the right to clean and safe water in adequate quantities. South Africa, everyone has the right to have access to sufficient food and water. Albania, the state within its constitutional powers and the means at its disposal aims to supplement private initiative and responsibility with a healthy and ecologically adequate environment for the present and future generations. Eritrea, the state shall have the responsibility to regulate all land, water and natural resources and to ensure their management in a balanced and sustainable manner and in the interest of the present and future generations, and to create the right conditions for securing the participation of the people to safeguard the environment. Azerbaijan, everyone has the right to obtain information about the real condition of the environment and to receive compensation for the health or property damage caused by the violation of ecological law. Georgia, a person shall have the right to receive complete, objective and timely information as to a state of his, her working and living environment. The fifth group, which does not yet include an explicit right to environment, but those countries which guarantee rights which are ancillary to rights to environment, are United States, Canada, Japan, Australia, New Zealand, China, Oman, Afghanistan, Kuwait, Brunei, Darussalam, Lebanon, Laos, Myanmar, North Korea, Malaysia and Cambodia. It can be seen that almost all constitutions in the world have recognized almost some aspects of right to environment. However, there is an ongoing debate about the scope and potential utility of the inclusion of right to environment in national constitutions. Those who agree argue that the potential benefits of constitutional environmental rights include stronger environmental laws, improved implementation, improved enforcement of policies, greater citizen participation in environmental decision making, increased accountability, reduction in environmental injustice, level playing field with social and economic rights, better environmental performance. At the same time, critics argue that constitutional environmental rights are too vague to be useful, redundant because of existing human rights and environmental laws, a threat to democracy because they shift power from elected legislators to judges, not enforceable and likely to cause a flood of litigation. Though there is a difference regarding the significance of inclusion of right to environment in the constitutional framework, as of 2012, 177 out of 193 UN recognized countries have recognized the right to environment in their constitution. Right to environment in India. The supreme law of the land in India is the Indian Constitution. The Constitution of India, when it was originally adopted in 1950, did not contain any direct and specific provision regarding the protection of right to environment. However, certain specific provisions have been incorporated by the Constitution 42nd Amendment in 1976 and subsequent such amendments. As a result of these changes, various provisions in the chapters of directive principles of state policy and fundamental duties to protect and improve environment have been incorporated within the Constitution. The Article 48A, which is a directive principle of state policy, was introduced by way of the 42nd Amendment in the year 1976. It states that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Further, Article 51A Clause G, which is a fundamental duty brought in again by the 42nd Amendment, states that it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. One unique feature of Article 48A and 51A Clause G, the Constitution of India, is that the protection of environment is a fundamental duty not only of the state but also of every legal person. In Sachidanand Pandey versus State of West Bengal, the Supreme Court observed whenever a problem of ecology is brought before the court is bound to bear in mind Article 48A and 51A Clause G. It is to be noted here that there are various provisions in the Indian Constitution indirectly referring to the protection of environmental rights. For example, Article 39 Clause B provides that state shall direct its policy towards the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Article 39 Clause E provides that the state shall direct its policy towards the protection of strength of workers in men and women. Article 47 provides that the state shall regard the raising of the level of nutrition and standard of living of its people and the improvement of public health as among its primary duties. The improvement of public health also includes the protection and improvement of environment, without which public health cannot be assured. Likewise, Article 48 deals with organization of agriculture and animal husbandry. It directs the state to take steps to organize agriculture and animal husbandry on modern and scientific lines. All these above mentioned provisions have an implication on the protection of right to environment. Judicial interpretation in India has further strengthened this constitutional mandate to guarantee right to environment. The right to live in a healthy environment as a part of right to life under Article 21 of the Constitution has been recognized in the case of Rural Litigation and Entitlement Kendra versus the state of Uttarakhand. Also in M.C. Mehta versus Union of India, the Supreme Court treated the right to live in a pollution-free environment as a part of fundamental right under Article 21. Further, in Subhash Kumar versus State of Bihar, the Apex Court conclusively held that right to environment is a fundamental right of every citizen of India and is included in the right to life guaranteed under Article 21 of the Constitution of India. Various dimensions of right to environment, such as right to a wholesome environment, polluter pays principle, precautionary principle, sustainable development principle, and intergenerational equity, all have been recognized by the Indian higher judiciary as a part of the fundamental constitutional scheme under the Indian Constitution. Please let me sum up by saying that we today discussed through this briefing right to environment under various regional and national level environment protection regimes, which provide for a right to clean and safe environment. The discussion essentially was divided into three parts: the regional regimes, national regime, and Indian specific regime. At the regional level, we discussed the protection given under the American Declaration of Rights and Duties of Man, 1948, Inter-American Commission on Human Rights, European Commission for the Protection of Human Rights and Fundamental Freedoms, American Convention on Human Rights, 1969, African Charter on Human and People's Rights, 1981, ASEAN Agreement on Conservation of Nature and Natural Resources, 1985, European Social Charter of 1996, and the Charter of Fundamental Rights of the European Union, 2000. The second part of the discussion discussed national constitution of states like Afghanistan, Chile, Mali, and Turkey. It also introduced to you the states which guarantee specific right to environment like Russia and Ukraine. The discussion gets finally concluded by introducing other rights provided for in states' constitutions and the right to environment as provided for in countries like US, Japan, China. Lastly, we concluded our discussion by discussing in detail the scope and the evolution of right to environment as a part of Indian Constitution, the fundamental rights, the directive principles of state policy and fundamental duties, as amended by the Constitutional Amendment Acts, especially the 42nd Amendment of 1976, and also as interpreted by the Indian Supreme Court through various public interest litigations filed prominently post the decade of 80s by people like M.C. Mehta and Mr. Godavarman. Thank you. I hope this was interesting and informative. Thanks for listening.